Welcome, everybody. Thank you for attending today over your lunch. My name is Jessica Lemie, and I'm a member of the State Bar and a member of the CLE Committee, as well as the Hughes County State's Attorney. Before we get started, I just want to go over a few things about today's event, as well as some other information. First off, lawyers and law students, if there are issues or you're struggling or with alcohol problem, depression, anxiety, there's always Lawyers Concerned for Lawyers, and it's a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with Lawyers Concerned for Lawyers is strictly confidential and privileged. For more information, call Becky Porter at 605-391-5191. Becky is an Lawyers Concerned for Lawyers member, and your communications with her are likewise confidential and privileged. Also, South Dakota State Bar members and their families also have access to the Sand Creek Member Assistance Program, which includes a 24/7 hotline. To reach trained professionals at any hour for a confidential discussion and assessment, please call Sand Creek at 1-888-243-5744. So with that, today's presentation will last about approximately 1 hour. You will have the opportunity to submit text questions to today's presenter by typing your questions into the questions pane of the control panel. You may send your questions at any time during the presentation. We'll collect these and then address them during the question and answer session at the end of today's presentation. I want to say thank you to the State Bar as well as the CLE Committee for all of their support in putting on today's program. And now, without further ado, I'd like to introduce our presenter, Professor Rose. She continues to teach her beloved course of Evidence and Trial Techniques at the University of South Dakota Knudson Law School of Law. She was elected to a 3-year term on the board of directors of the National Association of Legal Advocacy Educators as a Region 12 representative. In this role, she represents the interests and concerns of advocacy professors in North Dakota, South Dakota, Minnesota, Iowa, Nebraska, and Wisconsin. Professor Rose is involved with trial advocacy consulting and training as an instructor and presenter, and also National Institute for Trial Advocacy. Her article, Advocacy in Action, Teaching Evidence to Interleave the Doctrinal and Practical, was selected as the inaugural winner of the Stetson University College of Law's Advocacy Writing Competition. At USD, Professor Rose continues to grow the trial team, and the trial team always welcomes South Dakota lawyers who would like to get more involved. And with that, here's our presenter, Professor Rose, for today's presentation.
Thank you so much, Jessica. It's so great to be here with everybody today. And today what we're going to be talking about is one of those things that we all know that we need to be using in our trials, but there's always just those little bits of hiccups. And so I'm here to offer you some tips and tricks for making your exhibits work well for you, both in trial, in your closings, and throughout the rest of your practice. So let's talk about that here today. Now, why do exhibits actually matter? Exhibits matter because otherwise all we're doing is listening to somebody tell a story. And unfortunately, what often happens in those situations is you get a little bit of that Charlie Brown adult noise, right? We can all recall back to watching the shows on ABC at Christmas time and Halloween and hearing the adults go, wah, 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 wah. If we're not breaking up our trial presentations by including exhibits and making sure that we use them effectively, we are actually undercutting our persuasive power of our cases. They corroborate the testimony. They allow the jury to see that people are not just making things up when they get on the stand and start to testify. There is actual independent evidence that they are more likely to believe because of certain biases we have about machines. They are, generally speaking, more reliable, at least if they can pass through the authentication gate, they should be. And they're memorable because it engages another sense. It permits repetition and allows you to engage in multiple modalities of presentation for your trial. So instead of just describing the car accident or showing the photo of the car accident, you can do a demonstrative where you have the witness describe which way the vehicle was going and move the vehicle on the diagram. This engages multiple senses, and what the science of learning shows us is that when we engage multiple senses, we actually are learning and remembering better. So this enhances our ability to be persuasive in our cases. And really important and effective for all of us is that they can't be cross-examined. There is nothing that you can do if the bank records in a fraud case show that there was fraud. There is no cross-examination moment that F. Lee Bailey is going to be able to teach you that will show you a way to get away from that hard, cold information. In short, they are the things that make the rest of the trial come to life. They make it breathe. They give people the surrounding information that was present at the time of the case and allow the jurors to make the judgments for themselves as to how those matter. Now, what do you need to know in order to effectively use exhibits in your practice? You need to know authentication law. Now, that may sound scary, but it is a very, very, very simple concept that we're going to talk about here today. You need to understand how demonstrative evidence works. Demonstrative evidence always trips lawyers up because it's one of those things that is a rarity in our trial system. We will create the demonstrative in court, we will use the demonstrative in court, and then it doesn't go back to the deliberation room. With it not going back to the deliberation room, there's all kinds of things we need to be sure that we do before we conclude using that demonstrative. We're going to talk about those today. And you also need to know how to admit and use the exhibits effectively. That's going to be my point in my presentation here today with you all. Now, one of the things that's most important is keeping track of your exhibits as you go through your trial. This is always one of those situations where you've got a nightmare of paper that you're dealing with. You have 87,000 trial binders, 45 accordion folders, and you really need to be able to, at a moment's notice, know which exhibit has come in, how they have come in, and what that is going to affect the rest of the case with. So keep a chart at your counsel table. I've given you an example here. Here you can see that there's space for exhibit, and a space to say if it was in or out, and a space to say what it was marked as. You could add another column onto this very easily that talks about any particular evidentiary issues or objections that were brought up to the exhibit. It's a nice way to keep yourself organized. And the reason that is so important is one of the things that we as trial lawyers like to occasionally forget is that a case does have life after trial. There is the appellate process. And so we need to be crystal clear on that appellate record. If you use a chart like this, then when you go back and look at your transcript, you will be referring to the exhibits as the correct name that they came in as it went through trial. This concept is called a center sheet. It's really easy to keep at trial with you in order to make sure that you stay organized, that you stay on top of it, and that you're the advocate who can look at the judge and say, no, Your Honor, I understand that that was pre-marked as Exhibit 3, but it actually came in as Exhibit G, and we need to make sure we're referring to it appropriately for purposes of that appellate record. Excuse me. Now, authentication law. Before we admit anything into a case, it's got to be able to clear the hurdle of authentication. South Dakota Codified Law 1919-901 gives you the text, right? Let's talk about what this means outside of the legal language. We have to be able to show that whatever item, whatever photograph, whatever document, that the item we want into evidence is what we're claiming that it is. There are different types of foundational questions that we're going to need to be able to clear in order to get through authentication. Authentication is one of those gates that you have to look at first and foremost when you're going through. Why? Because you have to be able to have a witness that has the requisite personal knowledge to be able to testify to the exhibit. They have to be able to answer these foundational questions that we're going to go through today. And then it becomes a strategy question. Which witness is it most powerful to have authenticate the particular document? We know that photographs don't need to be authenticated by the person who took the photograph. Is there somebody else in my case who is better suited to go ahead and be the person that I authenticate that photograph through? But I need to be able to produce sufficient evidence to show that whatever it is I am claiming this exhibit to be, the photograph, the document, the murder weapon, it is in fact that item. There are several things that we've got to consider here. So let's talk about some brain-saving litanies in space, because you guys know I'm all about efficiency and I am all about making sure that you have the ability to stand up in court and make your argument most effectively. So when we get to the point where we are going to be admitting an exhibit into evidence, the first thing that we should do is ask a series of setup questions. It shouldn't be the case that we're just jumping to admitting an exhibit. Give yourself a little bit of time in your questioning to set up the admission of that exhibit. So if I've got a photograph of a scene of a car crash, before asking the questions to admit that photograph scene, may well ask my witness, do you remember what that scene looked like that day? What about that scene was so impactful to you? Would seeing a photograph of that scene help the jury understand your testimony today? And then I have set up the fact that this witness has this connection, that we can move through it. These are things that we want to do because of storytelling, guys. Trials are part of the most ancient human art form of storytelling, where we teach one another and we ask one another to do things through the power of story. By setting up the exhibit properly and giving it its drumroll introduction, if you will, you are cueing the members of the jury in to the fact that something important is about to happen, that there is about to be something that they need to consider and consider closely. This means that when you start to do the more formal part of this process, where you are going through the questions that we have to ask for legal purposes, they're engaged, they're interested, they want to know what is going to happen when they see this exhibit. After I ask that series of setup questions, we have the initial approach, where first I'm going to ask the court permission to approach the witness. Let's talk about a couple of things with approaching that witness. Number one, I need to make sure that I go and do a drive-by with opposing counsel and show them what I'm going to show the witness on the stand. Why? Professionalism matters. And even though they probably have access to every single exhibit through the discovery process that we've done, I don't ever want to be the attorney who is accused of hiding the ball with my opposing counsel on something that I'm doing. So it's very simple. I'm going to stand and say, Your Honor, may I approach the witness with what has been marked for identification as Exhibit A? And as I'm saying that, I'm already walking over to opposing counsel's table to show them what I'm talking about. I don't need to put this on the record yet, but I do want to make sure that I do it every single time before I begin my foundational questioning. Also important to remember here, everyone, is the fact that this exhibit, while it is pre-marked for identification, and while you may have had lengthy motion in limine arguments or motion to suppress arguments about it prior to trial, has not yet been admitted into evidence. Therefore, when I go to approach the witness with the copy of the exhibit, I need to make sure I do so in a fashion that does not allow the members of the jury to see it. Why? I am risking a mistrial if I do. We all know that under the rules of evidence, we have an obligation to not allow the jurors to see otherwise inadmissible evidence. If there's something that's contentious, if there's something that there's been a lot of litigation about prior to the trial even beginning, I need to make very, very sure that until the point I have cleared the hurdle of admission into evidence, I don't let the members of the jury see it, or I'm going to sacrifice something that may be huge for my case. Apologies for the typo in that last slide. It's time for your foundational questions. Now, there are different foundational questions that we need to ask depending on the type of exhibit that we are dealing with. If we are dealing with the original copy, the original thing that the witness has previously interacted with, if it's the original copy of the contract, if it is the original photograph, if it is the original copy of, you know what, we're going to stick with the contract example for right now because my brain decided to delete the other example that I had in my head. These are the questions that I'm going to ask, and I'm going to ask them in this order. I've handed you what's been marked for identification as Exhibit A. Do you recognize it? The witness is probably going to say yes and give me the answer to my second question within that answer, but I need to make sure that I am engaged, that I am listening, and that I am paying close attention, because if they do not tell me how they recognize it, I need to get that on the record. Why? For purposes of authentication, they need to have that requisite personal knowledge. And so we need to explain to the jury, I recognize this is a copy of the contract that I signed on August 5th, 2020. Then we ask the question, is it in the same or substantially the same condition as the last time you saw it? Same and substantially the same condition is the language we use when we are dealing with originals. We are trying to show that no alterations have been made to whatever this is. So say that I'm in a case where I am dealing with a drug trafficking case and we are dealing with the resulting seized heroin, right? And we've got bricks of heroin because it was a major bust. I need to ask if those bricks of heroin are in the same or substantially the same condition as the last time that was seen. Things like, yes, other than the fact that there's been evidence tags put on it, are fine. But note this last bullet point. If you are in a criminal case and we are dealing with a situation where the item in question is not something that is readily and easily distinguishable from other items, you need to go ahead and establish the chain of custody issues here. So have your police officer walk back through how they know that this is the cocaine that came from the bust of this defendant. The way that I tell my students to think about it here at USD is this. I encourage them to think about the Netflix show Daredevil, right? And in the Netflix show Daredevil, one of the street gangs puts a stamp on every packet of heroin that they put out. Now that's probably going to make that heroin fairly readily and easily distinguishable, right? But what I would need to do in the case of the brick situation that we were talking about before, I've now got to walk my officer through the chain of custody, through how that works, and explain that this still shows, based on those chain of custody documents, that this is the heroin from the bust of this defendant. Because remember, the rules of evidence are all about trying the facts of the instant case with only the information of the instant case to be used. We're not trying to get outside information. It's all designed to filter that down. This way, I establish the chain of custody and then can move on to the request for admission of the particular item. But what if it's a copy, Professor Rose? If it's a copy, I'm going to ask the same first two questions, right? I'm going to ask them, this has been marked for identification as Exhibit A. Do you recognize it? How do you recognize it? And is it a fair and accurate copy of that document? This is where your witness should say things like, yes, outside of the fact there may be a Xerox smudge here or there. It's okay to point out where there are issues. You need to do so in order to make sure that the appellate record, again, keeps its standard of being clear, keeps its standard of being up to date. The reason that this becomes important in particular is if you've got a situation where the best evidence rule would otherwise apply and you should have the original, we need to cover why this is a copy, why the copy is being used, how that is in there in our lead-up questions and in our follow-up questions to these particular issues. So again, if I'm dealing with a copy of what the witness was once familiar with, is it a fair and accurate copy? Where does this often come up? When we're dealing with digital forensics, right? When we have a download of a cell phone or a computer. Is what is contained on this CD and DVD a fair and accurate copy of the download you did of that cell phone? Yes, based upon my prior review before trial, it is. Let's talk about that for a minute. If you have something that is so large that it has to be contained on a digital disk, Professor Rose, how can you authenticate it? How can you go through it? It's through your witness preparation prior to trial. You bring your witness in with you. When does this often come up? For example, in child porn cases. If you have information that's sensitive that has to be stored in a certain way, you review it with your witness beforehand. You have them initial the front with a date on the jewel case that contains the CD and include that when you're asking those questions. Well, how do you recognize it? My initials are here and the date is here from when I reviewed it at your office. Based upon that, is that a fair and accurate copy of the download you did of the defendant's cell phone? Yes. At that point, I would go and move for admission, which we'll talk about here in a minute. If we're dealing with a photograph or a diagram, instead of fair and accurate copy, we are now going to use the language of fair and accurate depiction. A no doesn't necessarily always rule it out. When is that the case? Say, for example, that the events in question happened at nighttime and your investigator went back and got a picture in the middle of the afternoon, but it's the only photograph that you have prior to being ready to go to trial. So what are you out of luck? Can you not use the photograph? No, you absolutely can. Does this fairly and accurately depict the area of this store? Yes, it does. What, if any, differences are there between this photograph and the way that it would have appeared on the night in question? This photograph was taken during the day. Other than that, there are no differences. These are simple things that you can carry through in order to make sure that you get use of that evidence. Sometimes we don't have the ability to pull back and get the other things that we would like when we're doing our investigations. We have to take our time and go back through and deal with what we've got. That doesn't mean we have to sacrifice our proof. You just need to make sure that you are going through and covering any differences. It's on opposing counsel to raise the relevance objection to you, but here's the deal. If it's something like this photograph was taken during the day and the events in question occurred at night, Your Honor, opposing counsel's argument goes to weight of the evidence and not admissibility. And as this court is well aware, the question of weight is the question for the fact finder, here the jury only. Opposing counsel is free to cross-examine on that point should they wish during their questioning time, but this is not enough to kick it out of 401 and 403 appropriate relevancy. Same is true if we're dealing with a diagram. When does that often happen? Car accidents or police reports where there's a quick sketch of the way that things look. The fact that it's not to scale does not mean that it is automatically going to be kicked out of admissibility. The fact that it's not to scale is a cross-examination point for opposing counsel if it's appropriate, but it's not something that's going to rise to the level of making the probative value of this evidence be substantially outweighed by danger of unfair prejudice, confusion of the issues, wasting time or needlessly cumulative evidence, which is our standards under 401 and 403. Let's take a minute to talk about our relevance standard, because we know that's going to be one of the other hurdles that we have to clear after we line up these authentication questions for our exhibits. As you are doing your trial prep and in your case analysis, you need to make sure that any exhibit you know you have pre-planned and pre-gamed out your evidentiary argument for its admission, opposing counsel's evidentiary argument for its exclusion, and your response to that argument. As you go through, you can see where you're going to have issues of relevance, issues of personal knowledge, issues of hearsay that are contained within documents. You have the ability prior to trial to sit down and go, no, I know that I can use that particular statement because under 8034, it was a statement made for the purpose of medical diagnosis or treatment to the EMT, and therefore the fact that it's contained in this report does mean that it can come in. Game planning it is everything when it comes to these exhibits. You want to take the time to break those things down for yourself. Think about the chart that I showed you in our last Law and Lunch with the proof chart, right? You can do that for every single piece of testimony, every single exhibit that you want to bring into trial. Is it tedious? Yes. Well, what does it do when you get to trial? You have the ability to almost have a supernatural recall of how these evidentiary arguments are going to go. You have the ability to sound as if you are giving an evidentiary treatise at the spur of a moment, but really it's all come in the planning prior to the event. Now, once all of our foundational questions are answered, it's time to turn back to the judge. I'm going to tell you all this right now. You all know the judges here in South Dakota. You know what their expectations are. You know how they prefer things to be moved into evidence. Some judges want you to say, Your Honor, we move into evidence. Some judges want you to say, Your Honor, we offer into evidence. The one thing I am going to ask you to never say is at this time, because as opposed to what other time are you doing it? Those of you who have been in classes with me before are laughing because this is a typical Professor Rose rant. But what we're going to do is we're going to stand firm in the fact that we know we've covered our evidentiary bases. We know that we've gone through and we've gotten our authentication clear. We know that we've set the question up appropriately such that there's no question as to personal knowledge. And I'll give you guys a tip and trick. If I know for a fact that whatever document I have has hearsay in it, I'm going to ask the witness questions that would give the indication and the foundation for the exception or exclusion to hearsay that I'm going to apply. What do I mean by that? If I've got a business record that I am seeking to admit, I'm going to walk through with the witness prior to attempting to admit that document. Are you a custodian of these records? Are they kept in the regular course of business? I'm going to go through each of those things so that when I turn to admit and opposing counsel stands up to object to hearsay, Your Honor, this would be an exception under Federal Rules of Evidence 8036, the business records exception. I just laid the foundation with this witness if you'd like me to review it. Don't give yourself the extra duty of having to do that after the fact. Ask it in those lead-up questions that we were talking about before. Once we get the particular item into evidence, we're going to move on to the next question. When we do so, we got to talk about publishing for a minute. There's various ways that we're going to publish our exhibits. We don't ever want to have the situation where we admit something and then we put it away and we don't ever talk about it again. If the jury doesn't see it, they're not getting the full benefit from it. If the jury doesn't see it, you're not maximizing your persuasive power. If the jury doesn't see it, they're going to wonder why you spent all of this time doing what appears to them to be a very archaic medieval dance of admission, only to not show it to them. So here are some options for you. PowerPoints are a great way to display information in a courtroom, provided you have the appropriate technology. I am a big fan of blowing things up on 24-inch by 36-inch film boards. Why? There's something visceral about doing that, about making it be seen in that fashion. You can also do handouts, but there is a danger with that. When you have a piece of evidence that is the majority of which is text, if you throw that up either on a PowerPoint or a phone backboard, quite frankly, you're running the risk of having them read that while you're asking questions. So if you're gonna do handouts, if you want them to see it right now, you may want to give a pause to the questioning and allow the members of the jury to flip through that. If instead you're going to walk through that document with your witness and highlight certain portions, you may want to use the PowerPoint instead, because now that you've admitted the document into evidence, you don't have to publish every single page. You can now selectively publish page 3, page 6, page 9. Well, opposing counsel's objecting, Professor Rose, that's great. They can invoke the rule of completeness, stating that they want to go through other things during their cross-examination time, but you are entitled to put forth your case the way that you want to for a full and compelling evidentiary narrative under Old Chief versus United States. So you can selectively publish those things. The last one that I have noted here is the Abby Rifkin method. Abby Rifkin is a prosecutor from Miami in Florida who I had the great pleasure of learning from. She's one of those people who's on Dateline all the time with all the incredibly wild cases that come out of Florida. And she talks about taking an exhibit, having it printed on a good cardstock 8.5 by 11 piece of paper, holding it horizontally in your hands, and walking it down the jury box. Why is that so powerful? Why is that so important? Why am I emphasizing this to you all? Because there is an incredible moment that happens between attorney and jury member when you choose to publish a piece of evidence in this particular fashion. You are showing them, here it is. Here is the thing that I need you to look at. And you get to have a human moment with them where they have to look at it and then make eye contact with you. Abby told a story about how she was dealing with a very violent case and she stood in front of that jury box for 5 minutes until every single member of that jury looked at that photograph. It also allows you to buy some credibility with the members of the jury when you're dealing with photographs that are of a sensitive nature. By not choosing to blow it up and make a huge deal out of it, but by showing it to them, you're saying this is the important thing that we are dealing with right now, you and I. We don't need to broadcast this to the rest of the courtroom. Is it something that you should do for every single exhibit? No, of course not. It would become tedious, number one, and number two, it's something that allows you to have that moment of connection. Use it persuasively in your storytelling when there's something you really need them to understand. When there's something you really want them to marinate on, give it the breath in the courtroom in order to be able to do so. Well, what about demonstrative exhibits? They don't go back to the deliberation room. Let me say that again. A demonstrative piece of evidence does not go back to the deliberation room, but you absolutely need to use them because they are incredibly powerful tools. This way you can get the witness off of the stand and have them interact with the exhibit. And again, like we talked about earlier in this presentation, it prevents the dreaded Charlie Brown adult noise of just talking being the thrust of your case. By getting them off of the witness stand, by having them interact with the photograph, with the phone call records, with a diagram of the scene, you are enhancing the storytelling that is going on. You are increasing your persuasive abilities in front of the members of the jury. But here's a couple of things that we need to talk about with this. After we've gone ahead and gone through the admission process, witness, would interacting with a copy of the exhibit aid the jury in understanding your testimony today? If they say yes, which they should because we've done our job and done our witness prep, then I'm going to ask the judge for permission to have them get off of the stand. Once that's done, we're going to mark up that exhibit. We're going to go through it. We have to make sure that the responses that we're dealing with keep the appellate record crystal clear. You need to make sure that as your witness marks on the diagram the path that they took that evening, that you are making sure that they are either saying out loud, I walked up the left side of the street here heading north before I turned right. Or that after they make the mark, you say something along the lines of, let the record reflect the witness is marked up to Jackson Street where they have marked a right-hand turn. Why is that important? I'm going to do what I usually do, which is teach through story and example. One of my positions prior to becoming a professor was as a statewide prosecutor down in Florida. We had a massive case that came out of Ybor City, a nightclub. There had been a shooting, and one of the state attorneys got the witness off of the stand with a step down to interact with a diagram of the club to show the jury where the shooter had stood and how he progressed through the crowd that night. But the transcript was vague. And when I say it was vague, I mean, where was he standing when you first saw him? Here. After you saw him there, where did he go next? Here. After he was here, what did he do? He shot 3 people, here, here, and here. After he shot those 3 people, you all cannot picture the way that it looks, right? So the rule is, if you can't close your eyes and have a mental picture or a mental video of what is going on while the witness is marking up the diagram, you have not asked sufficient questions, and you need to ask more, or the appellate attorneys in your office are going to come find you and want to beat you with a stick because you have given them nothing to keep the case safe. That case resulted in a dismissal of multiple convictions because the state had not done its job. It is that serious. You are the guard of the appellate record while you are in the trial lawyer position. You must make sure that it stays clear. Timelines or charts that get created, we're going to ask the judge for permission to do so. We're going to ask them for permission because it's their space. And while we control the courtroom in terms of whose house it is, so to speak, if you want to use that analogy, we always want to be respectful of the court. Why? It enhances our likability, believability, and credibility in front of the members of the jury. It keeps our judges happy, and it allows us to stay in that realm of being professional whenever we are working in a courtroom. So say I make a wonderful chart as I'm cross-examining a witness that shows how they didn't consider key things that they needed to consider. I can't just sit down as soon as I am done creating that chart. I can't say that that's done, that's over, we're moving on. I instead have to make sure that I ask the court to preserve the document as it currently exists and ask that opposing counsel make no mark on it. If I don't do that, they can get up and color all over my demonstrative. They can cross things out, they can write things on it, they can change it substantively because I haven't preserved it and it is solely demonstrative evidence. So before I sit down, Your Honor, I'd ask to mark this as Exhibit E1 for demonstrative evidence purposes, and then ask that it be preserved for later use in trial and opposing counsel make no mark on it. Why is this cool? Because you can build a chart that goes through multiple witnesses. So long as you redact the portion that they can't see because they were sequestered, you can literally build something that will show the members of the jury how your case stacks up in front of them. You can literally take a timeline and have it show the events of the case and then be able to use it again and be able to make it work for you in a fashion that otherwise gets left behind. We want to make sure that we're clear about those things because it allows us to tell the story. A note about creating these charts or timelines. You have to use the words that the witness uses. So if there's a specific phrase you need them to say, if it's your witness, you're going to talk about this during your witness preparation. You're not going to tell them how to testify. But if there's something that you know they've said before, that's going to be really important, and you have to use the language that they use. You cannot just start writing things down. Why? It's counsel testifying, and that's violative of the rules. Why is that violative of the rules? Because as an attorney, you are exposed to all of the information that wasn't ever going to come into evidence in the first place. You are exposed to all of the information that could not clear the hurdles of Federal Rules of Evidence 401 and 403 for basic relevancy tests. You know things that are outside of the instant facts of the instant case for the instant cause of action. The rules of evidence are designed to confine you to those that can come through in order to show that. You cannot be adding things otherwise. Otherwise, it's counsel testifying and you're violating your job and your responsibilities. So we're not going to do that. We're going to instead make sure that we ask good questions that get the information, and that on cross-examination, we have planned what it is that we're going to say so that we can write it on that chart. And we're always going to make sure that we preserve at the end. Lastly, before we move into our question and answer period, let's talk about the one thing that always happens with exhibits. You get through, you go through, you do the dance, you've authenticated it, you've done all of the evidentiary concerns, it's in evidence now, you know it's going to go back to the deliberation room. Thank goodness. And then we forget about it. And then we don't bring it back up. And then we don't use it persuasively in any of the remainder of the trial. We have to stop doing that. Use your exhibits. Make things visual. Make things interesting for your members of the jury. You can republish things through other witnesses, right? If they have the requisite personal knowledge to be familiar with the exhibit and you've already admitted it, you can republish it with them. You do have to ask some foundational questions. It's not the same litany of foundational questions that you had to ask when you were admitting it in the first place. It is instead, are you familiar with the photograph of the scene that was taken? Yes, I am. Your Honor, may I approach the witness with what's already been admitted as Exhibit A? Is this that photograph? Yes, ma'am, it is. Your Honor, may I republish? Therefore, I've now established the personal connection that this witness has. I've now got the photograph back up, and now they get to testify from their point of view about it. Why is that important? The same reason that we allow multiple forms of evidence to be presented in a trial is because we want to have as many different perspectives as possible to show it. As long as I'm not needlessly cumulative, which, let's review, the standard is needlessly cumulative, I'm just retreading ground over and over again, I can go back through and get a different witness's perspective. Why is that important? Because that's going to move the needle in my case far more likely or not on any particular issue that I'm proving. People like stories where there's multiple forms of proof going to the event that you are telling. If you can show that by republishing exhibits and having people be familiar with them and getting a perspective that is not exactly the same but has the same themes, you are enhancing your persuasive ability, you are adding to the weight of the evidence that is on your side of the case, and you are making it so that the jurors remember what you're talking about. Speaking of making sure the jurors remember what you're talking about, let's talk about closing arguments. So often, we get caught up in the language of the closing argument as the attorney that we forget that there is a whole other presentation element that we need to do. We must keep them awake through more than our words alone. If I have bothered to spend the time going through authenticating the exhibit, arguing with opposing counsel about its relevance, dealing with all of it, I need to go ahead and re-bring that up in my closing. Why? Because it's powerful, because it's reliable, because it was an exhibit that couldn't be cross-examined. It contains things that the other side could not get away from every single time. So I want to make sure that I bring those back up in my closing, because that way I can enhance my persuasive ability. That way I can enhance my story that I am telling that complies with the law that governs the case, the rules of evidence, the rules of procedure, and the rules of ethics. I am doing the thing to present the most persuasive case that I can, and I'm using the rules to do so. When we admit exhibits, that is what we are doing. That is what we need to make sure that we continue to do, and that's why we've got to bring them back up in our closing. What else can we do with some of those exhibits? If I've got a demonstrative that I've made a chart of, and I plan out the way my chart works, I can now use that chart and draw on that chart again to show that opposing counsel's client was negligent in their actions. I can use that chart to show that opposing counsel's expert didn't do even the most basic investigation prior to claiming that they knew what was going on in this case. I have a visual to point to. I have a way to show the members of the jury, this doesn't make sense. Professor Rose, what if you have a video or audio that you've admitted? Take the time in your closing to republish it, at least the portion of it that's most important to the case. Number one, it will give you a much needed break from talking all of the time. And number two, it brings the jurors back to the moment that it became admitted. Why is that important? It offers you the opportunity to talk about this trial as it happened. Humans are funny creatures. We all react differently in different ways. And if I am having my situational awareness up in the middle of a trial, and when I admit an exhibit, a witness gets upset or they get a little heated about it, I'm going to throw that up and we say, do you remember when we put in the body cam footage from the officer and how he started shifting his shoulders and resettling a lot and got flustered. Members of the jury, you are the deciders of credibility in this case. You get to decide which witnesses are believable and not, and why. And that's something that you should consider, that reaction, as you decide if you believe the officer as to what happened on the night in question. It allows you to bring them back to the trial to tie in what's going on, and again, add that to the weight of your argument and to your case. Exhibits can be daunting. It can seem like a whole lot of rigmarole, but if you use them effectively and use your litanies to get them in and make sure you're clearing these initial hurdles of authentication, you are going to end up adding tools to your trial techniques kit that are invaluable and will serve you well in getting the verdicts that you are looking for. So with that, I think we're ready for questions. If you guys have them, please submit them.
There are currently no questions in the questions tab of the control panel, but members that are attending are able to submit them now. So we'll just give them a couple minutes. Thanks, Professor.
Guys, take your time. What software programs do I recommend for editing videos or audio for use in closing arguments? I hate to be a law professor here and give you the answer that you all are accustomed to from hearing from this building, but it really does depend. It depends on what kind of photograph we're dealing with. It depends on what kind of audio we're dealing with. There are a variety of them. What I would tell you is that the most important thing that you can do there is do your research. I have used Adobe for that fairly exclusively, but that's just because I was working in the Attorney General's office in Florida, and that was what we had access to. You can use other ones, but what I would tell you is don't fall for, there are a lot of programs that are out there right now specifically designed for trial use, like TrialPad and all of those things. Make sure before you invest in them that you've gone through and that you've worked through them for yourself and see if you actually like using them. Oftentimes, a lot of the stuff that comes with Mac computers is also a really great source for software issues. Thank you guys so much for the compliments. It's really funny. You can spend a lot of money, right, on trial presentation, and it's becoming a thing where there are some firms that are just throwing every shiny bell and whistle at what they can do. But I don't think you need to do that with members of the jury. I think a lot of the times, the simpler that you can go with your presentation, it's actually better. And why? People don't necessarily have the fondest associations with attorneys, right? We all know this. They don't come to us on their best days ever. It's always when something is wrong. So if you come in and you're super flashy with your super shiny suit, you are actually effectively putting up a wall between you and the members of the jury. So low-cost solutions are never necessarily a bad thing. We want to look at making sure that we're presenting simply, that we're being honest, and that we take our moments to humanize ourselves in front of the jury as much as possible.
There are no other questions coming in at the present time, so we'll give it one more minute and then we'll turn it back over to Jessica for a few other closing remarks.
Do we have any other questions that have come in at this point? Well, seeing and hearing none, this is Jessica. I would just like to say thank you to Professor Rose. For anyone in attendance that does have any questions or any questions come up, please send that to the State Bar, and we'll get in the CLE committee, and we'll get them directed to Professor Rose. Once you leave today's webinar, you'll receive a survey on the presentation, and we would really appreciate it if you would complete that to provide your feedback. We want to provide information that you guys want to hear about. But with that, if there's nothing else, on behalf of the State Bar, thank you for joining us today, and everyone have a great rest of your day.
Thank you guys so much for the time, and if there's ever anything that I can do to help, please reach out.